Our next speaker will be addressing how arbitration has in fact already begun to play that role. I am very pleased to next introduce Martin Doe, Senior Legal Counsel at the Permanent Court of Arbitration in The Hague. At the PCA, Martin works closely with arbitral tribunals to resolve disputes involving various combinations of states, state entities, intergovernmental organisations, and private parties. Martin also assists the PCA Secretary General in carrying out his functions under the arbitration rules of the United Nations Commission for International Trade Law, UNCITRAL, and regularly assists in the diplomatic work of the PCA with its member states and other intergovernmental organisations. He was an active member of the drafting team for the Hague Rules on Business and Human Rights Arbitration, which were launched just in December last year. Martin, thank you very much for joining us. Without any further ado, you have the floor.
Thank you very much, Elise, and thank you very much for the opportunity to participate in this extremely interesting event. So without further ado, I'm going to start getting into more the procedural aspect and really what arbitration can do to help, and particularly by exploring where we've already seen some of these developments in a rather similar, if not identical context, dealing with disputes that are already arising in the context of human rights. And in order to do that, I wish to allude to some of the advantages of international arbitration that are also highlighted in the white paper. Here are four of the ones that are highlighted there, some of the classical ones: neutrality, the ability to bring in decision makers with expertise who will render final and binding decisions in accordance with law. And finally, a general flexibility and autonomy of the procedure which can be designed and adopted within an arbitration context. And just on the left of this particular slide, you see something I'd like to emphasize, which is that I come from an organization that really started with public law disputes as those that were treated in international arbitration. That is the CSS Alabama of the Alabama arbitrations at the end of the 19th century, which gave rise to modern arbitral procedure, which was codified in the bottom left corner in the 1899 Hague Convention, and arbitration still features as one of the principal means of peaceful dispute settlement in Article 33 of the Charter of the United Nations. And on the flip side, we have the challenge that Anna has identified, which is really also faced in the business and human rights context, which is we have some progress with states upholding their own direct duties. We have some progress with business and other stakeholders upholding their duties. But then we really have a quite serious deficiency in what is the third pillar of the UN guiding principles on human rights, which is access to remedy. How do we actually turn some of these commitments that various stakeholders are making into actual remedies that can be taken advantage of? And here in the 2011 UN Guiding Principles on Business and Human Rights, and in particular Principle 31, defined actually some of the criteria that we should be aspiring for what are non-state judicial grievance remedies. And here they are. So the real challenge that we have for trying to bring arbitration into a human rights space is to try and marry those advantages of arbitration with these criteria to measure the effectiveness of remedy. And thankfully, it was not too long after the UN guiding principles came into being in 2011 that these already had the chance to be put into practice. Sadly, it was due to a rather unfortunate event, the Rana Plaza disaster, the collapse of that garment factory in Dhaka, Bangladesh, which claimed the lives of over 1,100 garment workers who were working in that building, but gave rise to new impetus to say this is exactly the sort of thing that should not happen. And in that context, certain global and local unions negotiated with global brands that were taking advantage of garment workers in Bangladesh in order to conclude an accord on fire and building safety in Bangladesh, which included not only legally binding commitments, but also arbitration as the backstop in order to address that enforcement gap. And it was not too long after the Bangladesh Accord actually was concluded that this particular instrument was actually put into practice, not just in theory, but in practice there. 2 arbitrations were actually commenced under the auspices of the Permanent Court of Arbitration in 2016 for the alleged failure to actually uphold the commitments that were made in the Bangladesh Accord. And these cases began under the UNCITRAL arbitration rules, the rules that were just mentioned by Elise. But the particular context of arbitration of disputes involving human rights came to the fore quite quickly. You can see right here a quote from the tribunal saying, "This is not your typical public law arbitration. This is not a traditional commercial arbitration. It's not even a typical labor dispute." And so the tribunal had certain challenges that it had to navigate in trying to adapt the particular procedure to this highly specific context. For example, the tribunal grappled early on with the transparency regime, transparency and confidentiality that it should apply. It noted that there was a public interest in this particular dispute. In fact, quite a number of stakeholders that should be kept abreast of what was happening within the proceedings, but also privacy and reputational considerations that formed part of the heart of the bargain of the Bangladesh Accord itself, and indeed the practice that had already arisen early on under that instrument. And the tribunal did an admirable job of breaking new ground, not least because of the rather esteemed individuals that were conscripted into serving on this tribunal. But the tribunal nevertheless ran into some constraints that were imposed by the UNCITRAL arbitration rules, which were, of course, not conceived to be used in this particular context. As you can see here, there were some constraints on holding private hearings and the non-publication of the award of the tribunal, which were imposed by the UNCITRAL rules, even though it's questionable whether or not the tribunal would have made that choice had it been left to its discretion. So in 2018, led by a working group that was already studying the possibilities for arbitration in the business and human rights context, you had a drafting team that was put together specifically to try and adapt the UNCITRAL rules to tailor them to achieve the objectives of arbitration in the human rights space. And this, once again, requires trying to marry or leverage these advantages of arbitration in order to serve the criteria for effectiveness of remedy of human rights remedies. So taking some of those, accessibility and equitability, for example, the tribunal might, in this space, as exemplified in Article 5 of what was adopted in the Hague rules, might need to be more proactive and vigilant instead of just relying upon the theory of equal access and equality of arms in order to actually assure that accessibility and equitability. This is in many ways an expression of the neutrality of arbitration. The tribunal needs to, in fact, make sure that it is not used as a tool for human rights abuses itself. Legitimacy and predictability as well. The tribunal should be composed of persons of unimpeachable character and credentials if legitimacy is to be achieved within this particular space. This, of course, is an expression of that expertise that is sought to be leveraged in international arbitration. In respect of transparency, the default should be shifted towards openness in recognition of the public interest that is involved in disputes that involve human rights issues. Nevertheless, there need to be exceptions to take into account the reputation of potential respondents, but also the privacy and security of parties and witnesses and other participants in the proceedings. Indeed, there are even some kinds of disputes that do not require transparency, even though they may involve human rights issues. The Hague rules were conceived to even encompass B2B, business-to-business disputes regarding adherence to business and human rights standards, such as in a supply chain, that may not actually raise the public interest or the interests of stakeholders and right holders in such a manner as requires that they be aired in open court. This, of course, is again demonstrating the flexibility to tailor transparency, confidentiality, privacy to the needs of the particular case. And finally, rights compatibility. In respect of rights compatibility, the drafting team recognized that the whole objective is to further access to remedy and further human rights, both in process and in outcomes. And the two are linked. So this led to an interesting requirement that found its way into the Hague rules, which is the requirement that the tribunal shall state the reasons on which the award is based and shall satisfy itself that the award is human rights compatible. However, the commentary also clarifies that this is a requirement of procedure and form as part of the requirement of reasons and not of substance or applicable law. So this is not authorizing the tribunal to make a different decision than it would have otherwise, but rather encouraging the tribunal to think through the issues in the particular human rights context when it is rendering its award. This is actually promoting in a manner the enforceability of the decision. It is asking the tribunal to think about issues of public policy that might actually otherwise undermine the enforceability of an award that it might render. But as the thinking went along and more discussion was had as to adaptations of the UNCITRAL rules, the drafting team also began to come to the realization that a greater institutionalization was necessary in this space. As may be apparent in retrospect, robust human rights remedies require robust institutions. So for example, access depends in large part on costs. And in order to ensure this type of access, you may need an institution to make sure that the costs of the process itself do not create that barrier. In terms of legitimacy and predictability, it's no good to say that you want expert decision makers if you cannot actually ensure that such experts are actually appointed. The edifice of legitimacy of the arbitral mechanism depends upon it. And even more so, the measures necessary to ensure confidence in an arbitral system may change over time. So you actually need to delegate the ability to keep up with new challenges. And what good is publication and transparency if stakeholders in the public have no idea how or where to find the information about a given remedy mechanism? In fact, you need to try and and centralize it and be a little bit more proactive in making information available if it is to reach that goal of continuous learning and progressive development. And finally, what good is it to vindicate rights at the very end of the process if they're trampled over throughout the process? So once again, you will need an institution at the ready to put into motion a system for emergency relief, if that system for emergency relief is actually to be effective. And with that, I will conclude and pass the floor back to Elise and to my colleague on the drafting team as well, Diane. Thank you.
Thank you very much, Martin, for that perspective, both from the perspective of the PCA as well as a member of the drafting committee of the Hague Rules.